Well, hello and welcome back to the Canadian Virtual Sell Your Business Conference. My name is Mark Belage. I'm president of TorontoJobs.ca. Really excited to be joined by Rishi Bandhu. Rishi has advised and represented employers of all shapes and sizes across a variety of industries. In his practice at BLPC, he assists individuals navigate their rights and obligations in employment relationships. He provides trusted advice to business owners, managers, and senior executives. Rishi advises and represents his clients from a knowledge basis that is rich, current, and informed by practicality and business value. He strives to provide first-rate service and client communication. When necessary, Rishi is ready to litigate. He has appeared as an advocate in the Superior Court of Justice, the Ontario Labour Relations Board, the Ontario Human Rights Tribunal, and before labor arbitrators with a strong record of success. Rishi's career as an employment and labor lawyer started in 2003 at Canada's largest management side labor employment law firm. Rishi continued to build his expertise with two first-rate boutiques until late 2013 when he established BLPC. In 2018, Rishi returned to the University of Toronto as an instructor for the School of Continuing Education for its Industrial and Labor Relations course. So, thanks very much, Rishi, employment and labor lawyer at Bandhu Law Professional Corporation, talking about employee consideration of a business. So thanks, Rishi, welcome, and look forward to your presentation.
Thank you so much, Mark. Really appreciate it. It's a privilege to be able to attend. It's an interesting topic, buying and selling a business insofar as employees are concerned. And frankly, it still surprises me the extent to which businesses can get into hot water over this issue, and not consult an employment lawyer. Oftentimes, they're just consulting a corporate lawyer, and frankly, it surprises me the extent to which the corporate lawyers aren't getting some employment law advice either. It's not terribly difficult, but there are some nuances. So it's good to have this information, and of course, always good to consult with an employment lawyer in the context of a sale of business. So what I'm going to do is I'm going to take you through this concept of reasonable notice, because at the heart of the issue of a sale of business and employee issues is termination of employment. And it really comes down to what employees are entitled to when they are terminated as a result of a sale of business. The second thing that I'll do is I'll talk about sale of business specifically and how the common law treats the sale of business with respect to employment relationships. And then I'll get into the statutory protections, in particular the Employment Standards Act, how it relates to the unionized business, and then deal with some leave of absence issues if we have time, and then finally finish off with some practical considerations. If at any point in this presentation you have any questions, feel free to stop me. Let me know in the chat if you've got a question at all. I'd be happy to address them as we, or we can leave them to the end. It's up to you. All right. So reasonable notice. So this is just sort of a foundational topic to help understand what happens with a sale of business and a deemed termination. So under the law, in subject to specific contracts, employees are entitled to reasonable notice of termination of employment. To put it differently, if an employer wants to terminate employment, its obligation under the law, leaving statutes aside, is to provide what's called reasonable notice of termination. That reasonable notice is going to depend on each circumstance. So it's going to depend on the employee's age, how long they're with the employer, and the nature of their position. So historically, managerial employees or executive level employees would be entitled to more notice than, say, line level employees. Similarly, the longer someone's been employed somewhere, the more they're going to be entitled to notice. So there are two key questions in respect of reasonable in a sale of business. Number one, does the sale trigger a reasonable notice entitlement? And secondly, and this is often is the most contentious issue, does the purchaser inherit an employee service time with the seller? And we're going to explore both of those questions in the next few slides. So let's look at common law considerations with respect to a sale of business. So there's two forms of sale of business transactions. The first is a share sale. And so with a share sale, it's just the shares that are being exchanged in terms of the transaction. And what the law says in those circumstances is that there is no change in the actual identity of the employer. Just an underlying ownership of the shares are changing hands. So this is a quote from a case from 2001 in Alberta, Patillo and Murphy Exploration. The sale of a company's shares is merely a change in shareholders. It does not affect the company's ownership of its assets, and the company continues to exist as it did prior to the share sale. So with a share sale, there is no deemed termination of employment at all. Just effectively, it's just a name change in the corporation. So to the extent that the business that is purchasing these shares wants to make changes to the employment relationship after the sale, all those changes have to be negotiated directly with the employee, and it has to be supported by what's called valid consideration. Essentially, in exchange for the new agreement, the employer has to provide the employee with something of value, typically a raise or a bonus or additional vacation or benefits or something like that. Now, there are very different consequences when it's an asset sale. Now, when there's an asset sale, the identity of the employer does change, and the employment with the vendor ceases following the sale. So there was a decision many years ago called Noakes, and it's established what's called the Noakes rule. And that is basically that employees do not transfer with the assets. They are not assets, they are not chattels, they're human beings, they're not slaves, and so they have to consent to that transfer. So as a result of that, when there's an asset sale, the employment relationship is deemed terminated with the vendor. And if the purchaser is taking on that employment, that's considered a fresh employment relationship, whether it's oral or whether it's written. Now, there are some consequences to that, and one of those being that the cause of action against the vendor is negated or limited. So if I'm part of an organization that's been sold, my employment relationship is deemed terminated. I'm not provided any notice because I'm taking employment on with the purchaser. And so if the purchaser then lets me go, I'm without a remedy because I can't now go back to the vendor and sue them for wrongful dismissal because I've taken on the job with the new employer. So as a result of this, it created a bit of a vulnerability for employees. So situations would arise where a business would be purchased, employment would transfer over, or employees would simply start working for the purchaser, to put it a little more accurately. And then the purchaser, sometime after the transaction, would let the employee go. And now the employee is stuck because it can't go back to the vendor and sue the vendor for what may be a long service relationship. And with respect to the purchaser, they've probably only been employed for a very short period of time. So they're not entitled to much with the purchaser. As I mentioned, when we're talking about reasonable notice, the entitlement to reasonable notice is typically going to be a lot less when you're talking about short service. check out the chat if there's anything happening. Just want to make sure I'm not missing anything. I'm usually on Zoom, so
new to me.
although it is my second time. So that's the Noakes rule. Now, what's happened to recognize that vulnerability in employees with a sale is that the case law has developed to implicitly recognize the past service of employees. So a purchaser who buys a business assumes employment of individuals who were part of the vendor's business, may be liable for the employee's past service of termination in the following circumstances. So they've acquired the business as a going concern. There's no interruption, in other words, in the business. And now they're relying upon the expertise and the skill of a transferred employee. So for example, you've got a 25-year employee who's employed, say, by a grocery store. Purchaser buys that grocery store, takes on the employees, including that 25-year employee. In doing so, they're getting an employee that has intimate knowledge of the business, its customers, its policies, and it is allowing that purchaser to operate that business without skipping a beat. Right? So they're taking on a considerable benefit. Secondly, the purchaser doesn't contract with the employee on new terms. So remember, in an asset sale, you have a new contract of employment with the purchaser. It is a fresh contract of employment. So the purchaser is entitled to say to employees, hey, listen, I want to hire you, but as a condition of doing so, I need you to sign this contract of employment. And that contract of employment can be for any terms that it wishes. And one of the smarter things to do in that contract is to say, hey, listen, when you come start employment with us, it's a fresh employment relationship. We're not going to count your prior service with the vendor. We're starting the clock new. Now, there's an exception to that pursuant to statute, and we'll talk about that. But when we're talking about reasonable notice, the purchaser can reset the clock with the contract when it hires these employees. However, if they don't do that, and often they don't do that, and that's where they get into trouble, the courts will step in and say, hey, listen, you took on this 25-year employee, you benefited from their considerable skills and expertise, you're making money because of that employee, so we're going to require that you acknowledge all that employee's past service. So thirdly, as part of that contract, the purchaser doesn't clearly stipulate that the prior service with the vendor will not be recognized. And this is from two cases, very important cases, one in Ontario, one in Sorel, one in BC. Addison was the Ontario case, Sorel was the BC case. Now there's a bit of a difference if you're in BC. In BC, the law is a little more favorable to employees. So the law is that if a purchaser takes on employees and doesn't contract with them on new terms and doesn't reset their service, they will automatically recognize their service in the new contract. Addison's a little bit different in Ontario. In Ontario, what they say is, look, we're not going to automatically recognize service. It's not just an automatic flow through, but we're going to look at all the facts and circumstances of the case and see if it's a fair thing to do to recognize the employee's service. So again, and as I noted, and if it wasn't clear, if a purchaser is taking on employees from the vendor, they can negate that past service, provided that they do so in writing in a contract of employment and do so very clearly. And again, that's where good employment law counsel is going to come in. So what we've talked about up until now are the common law protections for employees in a sale of business situation and what happens on a sale of business. So as I mentioned, under the common law, there's no change in status if there's a share sale. There is a change in status if there's an asset sale. The asset sale deems employment to be terminated, and employment is a fresh relationship with the purchaser. And so, as I also noticed, there could be some harsh consequences as a result of that. So, what our government has done through legislation is introduce protections for employees directly into the employment standards legislation. And these protections apply to the statutory minimums that employees are entitled to. So in Ontario, for all provincially regulated employers, that legislation sets the minimum standards for termination, severance pay, minimum wage, etc. When we're talking about termination pay and severance pay, that is applicable depending on years of service. So termination pay maxes out at 8 weeks after 8 years of service. And if the employer has a payroll over $2.5 million, after 5 years of service, the employee is entitled to 1 week per year of service, up to a maximum of 26 weeks. So under the ESA, it's a maximum payment of 34 weeks. If you have an employee, for example, that's been with you for 26 years, that employee would be entitled to 8 weeks of termination pay and 26 weeks of severance. So how does that apply in a sale of business situation? So under section 9.1 of the ESA, service is deemed to be continuous between the vendor and the purchaser if the employee accepts employment with the purchaser. So we have an asset sale. The purchaser offers employment to an employee with the vendor. If the employee accepts that offer of employment, section 9.1 of the ESA will say, purchaser, you have to recognize all of the prior service of the employees that you're hiring for the purposes of the ESA. Okay? So what that means essentially is that they're recognizing past service for termination and severance pay purposes. Now, the saving grace to some extent is that with termination pay, if there's an interruption, then it resets. So, for example, sometimes a vendor will pay out the termination pay, and then there's a gap between employment with the vendor and the purchaser of 13 weeks. In that case, when the vendor takes on the employee, the service time resets with respect to termination pay. However, with severance pay is payable no matter what. So whether or not there's a break in service, severance pay is payable on all time spent with the employer. However, if it's been previously paid, it can be credited against future severance. So what often happens is a vendor will pay an employee severance pay to the employee on termination, and then that can get credited to the purchaser, thereby limiting its obligations down the road if it ever chose to terminate the relationship. And I mentioned this, so under section 9.2, if there's a gap of 13 weeks between termination with the vendor and the commencement of employment with the purchaser, then there's a fresh relationship. So I'll give you an example of how this all sort of played out in one particular case that went to the Court of Appeal in 2017. And this is the case of Krishnamurthy versus Olympus Canada Inc. So the defendant, Olympus Canada Inc., purchased the assets of a company called Carson Group in 2005. And then the Olympus Group enters a contract of employment with about 120 of those employees, including the plaintiff, Krishnamurthy, who is obviously a former employee of the Carson Group. He signs that contract of employment, and then the employment relationship goes on until 2015, when the Olympus Group terminates the relationship. And at that point in time, it says to Mr. Krishnamurthy, hey, listen, we're only going to be giving you the statutory minimums of 8 weeks plus severance pay, because that's what we agreed to back in 2005 when we purchased the company. So the plaintiff then takes it to trial, brings a motion for summary judgment, which is an expedited way of getting a decision from a judge. And the plaintiff invalidates the employment agreement, saying that there's no consideration for it. So basically what the plaintiff argued was that, hey, listen, under the Employment Standards Act, that guarantees that my employment relationship is going to be continuous after the sale of business. And because the contract of employment said that it's not going to be continuous, it's invalid, it's contrary to the law, it should be struck out. And the judge agreed with that. Essentially, the rationale that underlies that decision is that a promise to perform an existing obligation does not constitute valid consideration. So, in other words, if you have an existing employment relationship, you already have an employee, you can't just go to that employee and say, hey, sign this employment contract and then we'll have a fresh new relationship. And as consideration for that, I'm going to continue to employ you. That promise to continue to employ already exists, so the employer can't rely on that in order to bind a new contract of employment. So that's the rationale for the motion judge here, basically saying that, listen, the Employment Standards Act guaranteed that employment was going to be continuous. The employer, Olympus Canada, had to recognize that prior service because of the statute. Therefore, the contract wasn't binding. Olympus Canada takes that to the Court of Appeal, and the Court of Appeal finds that the motion judge was incorrect. And their reasoning is that Section 9 of the Employment Standards Act only protects the statutory minimums. So again, as we discussed, the statutory minimums are termination pay and severance pay. The common law is separate and apart from that. So Section 9 only protects that termination and severance pay. Section 9 does not require an employer to hire employees, and the sale of assets does terminate the relationship with a vendor. So as a result, the relationship with the purchaser is a fresh contract. And the purchaser is entitled to enter a new contract of employment with employees. And that's exactly what happened in this case. Olympus Canada purchases the assets of Carson. The law deems Krishnamurthy's employment to be terminated with the vendor. And the purchaser, Olympus Canada, offers Krishnamurthy a new contract of employment on new terms. And that's a fresh relationship. Provided that Olympus Canada recognizes Krishnamurthy's service with Carson Canada, that's all it needs to do for the purposes of the ESA. And then going forward, after the sale of business, it can reset the clock in terms of service so that that common law obligation is not continuing to accumulate, and it is either limited to the ESA or is based off of the start date in 2005. Hopefully that makes sense. I know it's a lot of information, but maybe you've already had a background in this, and this might be a refresher for some of you. So one important thing to note as well in terms of statutory protections is the Canada Labour Code. So in Canada, we have multiple jurisdictions of employment, and it depends on the province. So each of the provinces have their own employment standards legislation. In Ontario, we have the Employment Standards Act, but there is also the Canada Labour Code. Now, the Canada Labor Code applies to federally regulated employers, and there's only a handful of them, but typically they are the banks, interprovincial transportation companies, or telecommunication companies. Those are the big three companies that come within the Canada Labor Code. And so, under the Canada Labor Code, that's an entirely separate regime that applies, but it has similar requirements to the Employment Standards Act. So, under the code, Section 189 deems employment to be continuous between a purchaser and the vendor. Both employers have to be in the same federally regulated business. The terms have to be the same, and there has to be a transfer constituted pursuant to 189. And there can't be any sort of hiatus between the end date of the first employer and the start date of the second employer. So that's the Canada Labor Code. Most businesses do not fall within the Canada Labor Code. The lion's share of all businesses would be regulated under the Employment Standards Act. So a word about unionized employment. So we've talked up until now about non-unionized employment and what happens with a deemed termination. And again, that's the vast lion's share of sale of business situations. And so unions usually don't come into the picture. That being said, it does happen. And so when there is a union in the place, the Ontario Labour Relations Act applies. And so under the Act, Section 69 deems the purchaser of a unionized business to be bound by the collective agreement between the vendor and the union until the board declares otherwise. So effectively, there's an automatic transfer, and the purchaser of a business steps directly into the shoes of the vendor, inherits the relationship with the union, inherits all the obligations with the collective agreement. And if there is no collective agreement, it will inherit any certificates that have been issued by the Ontario Labour Relations Board in respect of the business. And so it's a good idea for, as a due diligence matter, for any individual or business thinking about purchasing another business to see if the business is covered by a certificate. That can represent a pretty nasty surprise if you're buying a business. Under the Canada Labour Code, there's a similar provision under Section 44.2. And then there's been a change to the Canada Labour Code effective September 1st, 2019. A provincial business that is sold to a federal business will continue to be bound by the collective agreement, and then a code will apply to existing labor board or grievance proceedings. So one very important consideration for businesses is leave of absences. So oftentimes what happens when a business is purchased is that the purchaser doesn't take account of employees who may be on a leave of absence. So that leave of absence may be because of a disability. It may be because of a workplace safety and insurance matter. But in any event, if they don't take account of that, the purchaser could very well find itself in a situation where it's the employee of these individuals who are on the leave of absence. These are just a couple of cases where that's happened. And so in relation to that, the purchaser of a business can actually inherit all of those workplace safety and insurance obligations. So they need to be careful in relation to that. So some practical considerations then. On the vendor side, provide as much notice as practicable to employees that are on leave of absence. Sometimes contracts of employment for management staff will have change of control provisions, and that can trigger severance entitlements. And so that can represent a significant source of liability for the vendor if a business is sold. So they want to be careful of that. Require offers of employment to all employees as part of the agreement of purchase and sale. So it's important to note that the vendor of a business is not necessarily off the hook when it comes to employees and sale of business. So if they've sold assets, an employee carries over to the purchaser then terminates the employment of an employee shortly after the sale. That employee actually has an option. They can go back and sue the vendor for wrongful dismissal because of the deemed termination, or they can go after the purchaser, or they can go after both companies. Take proactive steps to ensure business remains union free. Now, this is an important one because if a purchaser is interested in buying a business, they may run for the hills as soon as they find out that the business is unionized, there's a collective agreement, or there's a certificate in place. So a business that's contemplating a sale at some point down the road may want to take proactive steps to ensure that the business remains union free so that it has that maximum flexibility to sell the business. Again, consider severance for departing employees in exchange for a release. This doesn't typically happen, but it can happen. It can be part of the deal. There are benefits to the vendor and the purchaser. As I mentioned, if the vendor pays out severance to a departing employee, the purchaser can claim the credit for that severance. And as well, the vendor of the business can ask for a release, given that it's not required to pay out severance to the employee given the sale of the business. On the purchaser side, they're going to want to determine if there's any leave of absences pursuant to the Employment Standards Act or the Ontario Human Rights Code or the Workplace Safety and Insurance Act. Inquire about outstanding orders from tribunals or any court orders against the company. If there's any grievances or ongoing arbitrations before private arbitrators or before the Ontario Labour Relations Board. They'll want to ensure that the vendor is in compliance with with pay equity legislation. Pay equity legislation, as you may or may not know, is intended to ameliorate differences in wages between males and females, applicable to only certain organizations. Determine if there's any ongoing applications for certification or a union organizing drive. And then most importantly, if it's non-unionized, they're going to want to provide written offers of employment that limit the liability for severance. And this, again, is where purchasers of a business find themselves in hot water. So on that asset sale, provide a written offer of employment, reset the clock for severance purposes, but not the ESA, and include a clause that limits liability to the Employment Standards Act minimums. And that's going to require some expertise and that of someone who has knowledge and experience in employment law, because the laws on employment contracts and what constitutes an enforceable provision are always going to change. Well, I should say always going to change. Hopefully not, but they've changed quite a bit in the last couple of years, including in 2020. As I mentioned, they can utilize severance pay to create valid consideration to mitigate future risk and severance liability. So again, there could be a possibility where it's negotiated that the vendor provides severance pay, which the purchaser can then use as a credit against future severance liability. One thing I've seen happen is indemnity provisions. So if employees don't work out post-sale, it's often the case, the purchaser may be able to go back to the vendor negotiate some form of indemnity with respect to those employees. If there's a union in place, it's a good idea to review the collective agreement obligations, see how onerous they are, see if and if possible, negotiate with the union with respect to any amendments. And again, on the purchaser side, ascertain if there's any live grievances that will flow through to the vendor following the sale. So that's all I have. I see that there's a question from Rodrigo. How can a small business afford all the fees involved in selling the company? How big should you be? I mean, that's a good question. I don't know. I mean, all I can say is, if you're interested in selling your business, it's important to get proper advice, right? Proper advice is really a cost of doing business, in my view. That includes having a good CPA and a corporate lawyer, and an employment lawyer. Now, an employment lawyer is if you're a very small business, maybe a couple of employees, you may not need the services of an employment lawyer on a regular basis, but certainly at the time of sale, it doesn't hurt to get an opinion from a lawyer, or just have them in the background to evaluate any risks or potential liabilities. Again, the cost of not getting that advice and not doing things properly can be astronomical. Hopefully that answers your question.